Welcome to the 40-year recertification hosted by K. Bender Rembaum, and our special guest today and the provider of this seminar and webinar is the Falcon Group. So we welcome you and thank you for that. A couple of instructions before we do the intros. The chat today has been disabled, and you will be using the question and answer function at the bottom center of your Zoom webinar interface. Our speakers will get to the questions at the opportune times, depending upon what it is they're speaking about at any given point in time. Any questions they do not get to, rest assured they will receive spreadsheets containing all of your questions. So the questions will be answered either during or after the presentation. At the end of the presentation today, and this is very, very important, there'll be an evaluation we would like you to fill out. This is especially important for any CAMs seeking credit for this course, okay? Because we capture your signature and your CAM license number on this. So that will happen with a pop-up at the end of the webinar, and you will also receive the link for the evaluation. Tomorrow morning, we'll be sending out a post-webinar email to all attendees, which will also contain that link. In addition, the last thing I want to mention is that the course materials covered today will also be a link in that evaluation. So when you get that evaluation pop-up screen, there will also be a button on that screen to click and download the materials you'll be seeing today. So with that said, I'd like to introduce from the Falcon Group, we have Sinisa Kolar. He'll be our instructor for the course today, with our special guest instructor from our own Lisa Magill from K. Bender Rembaum. So folks, take it away. The floor is yours. Thank you.
Well, thank you very much.
Go ahead.
Thank you very much, Jeff. I just want to introduce myself. My name is Sinisa Kolar. I'm the Executive Vice President of the Falcon Group, and I'm pleased and honored to be presenting for all of you in this, by now, usual format, although for some different times unusual format, but I guess we are all learning to live with this new situation. Thank you.
Good morning, everybody. While there are plenty of legal issues that we have to contend with in connection with the 40-year recertification, I think it's very important for you as community leaders and as CAMs to understand the actual mechanics of what the inspection entails and what you'll need to face in the event there are major or significant repairs that are necessary in connection, in order to qualify or in order to receive your recertification. So I'm very, very glad that we have professional engineer, Falcon Group, and Sinisa working with us today, and I would like to turn it over to him for to begin the presentation.
Well, thank you very much, Lisa. So we have a presentation. I hope everybody sees it on the screens. If you're joining with a video conference link, we'll go over the presentation and have more of a dialogue and discussion between Lisa and myself, and as well answering your questions as we go along as Jeff said, the opportune times. So please ask your questions in Q&A section, and we'll try to address them, if not all during the presentation, then later on. So bottom line is, what is the 40-year justification? And the 40-year justification is a process that has been mandated by certain counties in Florida to ensure that your building is safe for intended occupancy. So basically, the legislation at some point determined the need to enforce the associations or onto associations to maintain their properties, to keep them safe and operable and operational throughout the times. And they figured out the 40-year to be a great time to start that. I guess that enough time has passed and the building has reached certain maturity that this becomes critical. So you can see the formal definition of what it is, but in reality, it's a way of ensuring that your building is safe for occupancy. Very important distinction is that this is not a code compliance project. And we'll talk about this in a sense of some misconceptions about the 40-year justification process, some experiences that are, related to this. But in reality, again, this is a maintenance project. It is not a code compliance project. There are certain items that need to be made up to code, or once certain repairs are required, they may be required to be up to code. But in reality, this doesn't mean that you have a 40-year building and somebody's going to come to you and say, okay, everything that was in place 40 years ago and has changed in the codes, you now have to fulfill. Another very important thing is this: it only applies to structural and electrical system, which means mechanical and plumbing system is not generally required to be included in this process, nor are they. What I like to say, not that it makes anybody feel better about it, but the building departments care about structural and electrical, but they don't really care whether you have AC or not. And there is a reason for that. The reason is life safety. Failure of structural systems or failure of electrical systems usually lead to loss of life, or could lead to loss of life, or damages to the property, injuries and such. So that's why it's important in building departments' eyes that we make sure that these systems are functional and operational. When mechanical systems and plumbing systems and systems of such nature do not perform, it is mostly for creates a inconvenience and a loss of enjoyment of the property, but not necessarily life-threatening conditions. Even though in Florida with the temperatures and humidity, it can be definitely challenging for some people, especially some pre-existing conditions. But on a global level, failure of electrical systems causes fires, and that can jeopardize the entire property. Same as the failure of structural systems. What counties does it affect? Well, only 2 counties for now are included in this particular program, and that is Broward County and Miami-Dade County. And there are slight differences between the requirements for both of these counties. There's always a question, what about West Palm Beach, and so on and so forth. To the best of my knowledge, West Palm Beach has been thinking about this for the past who knows how many years, and they're always on the verge of implementing it, but never actually did. Again, being that this program is for maintenance, whether this exists or doesn't exist in any other county throughout the Florida, it definitely, the structure of this program should be implemented everywhere individually by any association, because the goal, again, is to properly maintain the buildings. I don't know, Lisa, if you want to give some commentary on the creation of these systems or how this became in Broward and Miami-Dade County.
Sure. So everyone asks, why is it only applicable in Miami-Dade and Broward County? And is this a new thing that just sprung up out of nowhere? Well, it's been in effect in Miami-Dade County since the 1970s, and Broward County adopted it pretty much based upon the Miami-Dade County program in 2005, 2006 is when it was originally implemented. Why is that? Well, think about the development and the emigration to Florida. What happened in the 1940s? Well, of course, we were going to become involved in a war where a lot of people were stationed here in Florida, and the availability of air conditioning. So Miami-Dade County, Miami Beach became a very big focal point for development, and therefore it was one of the first counties to experience building failures as a result of the lack of maintenance or lack of standards or lack of periodic checks. So there were some very catastrophic failures that happen even to this day. I mean, in 2020, right in Hallandale Beach, one of the balconies fell at one of the condos on the beach in that area. And all the time we hear about problems that may result in loss of life or certainly loss of property. So that's where these programs came about. And I want to also impart to our participants today that it's not only condos and co-ops or high-rise buildings. You're going to talk about the actual parameters for what's included in the program. But if you're an HOA and you have buildings that exceed the size types in one of the two counties, then those buildings are likewise subject to this space safety inspection. So here are the requirements for Broward County. Go ahead.
No, I just want to say I put a slide showing some of the requirements for Broward County to complement what you were saying.
All right, so here are the requirements. So any buildings that are larger than 3,500 square feet, single-family dwellings, duplex dwellings are exempt. Some of the governmental buildings are exempt, but you low-rise condo owners out there, or HOAs that have significant recreational facilities, significant clubhouses and the like, you also are going to be subject to these requirements. Miami-Dade County, they exempt buildings smaller than 2,500 square feet, and they're and likewise exempt single-family homes and duplexes. But again, we can talk about a little bit more of the mechanics of what is included in the inspections when we move forward.
And I just want to add something which is important for Miami-Dade. Miami-Dade requires that parking and garage lighting levels need to meet the current code. So we talk about this is maintenance versus a code compliance project. Well, in a sense, Miami-Dade does enforce this particular item as a requirement to bring the buildings up to code when it comes to the 40, 50, or any subsequent certification, that all your parking and garage levels need to meet the current code when it comes to lighting levels. So that
this can really be confusing because you hear different things from different people. Different code inspectors or different building officials seem to have different opinions, but the parking lot illumination and some of the other requirements associated with like current codes are often thought about or mentioned in connection with these inspections, and working with an engineer that really knows the actual requirements of the code and how the building departments operate is really important for you to make sure that you as a building operator or building owner are attending to the needs for the program.
And I've seen some of the questions that I just want to answer because I think it's important for this section. Somebody asked, are the elevators included in the electrical report? Well, elevators are not part of this report for a simple reason, because elevators have an annual inspection. So without that annual inspection, you wouldn't be able to run your elevators. So in a sense, you have somebody checking and verifying that your elevators are operational and running every year. Therefore, there is no need for a 40-year certification. For these electrical systems and structural systems, you don't really have anybody from the building department or otherwise checking your systems to make sure they are operational and properly running. So in that sense, elevators are not part of this certification problem. What does this process entail? So bottom line, it is an inspection and a report. Inspection is a visual, mostly. Some destructive investigation may be required. That depends on the necessity to inspect certain items on the property, certain concealed areas that may be important for structural evaluation or electrical, and very important, it pertains to the entire property. So anything that is under the folio number for which the 40-year certification notice is issued will fall under this inspection, obviously from that structural and electrical component. Another very important thing is that this is not a report that is custom or to each property or each person performing this inspection. These reports are actually templated, and the templates could be found on websites of various building departments of Dade County, and you can now go and download them or Google for them. I'll show you some examples of the report, but in reality, the engineer has that report as a checklist and basically checks the property based on the requirements from in those reports and gives it a final evaluation at the end. So what is inspected in this? You can see some of the systems, foundations, roofing. Somebody asked the question, is the leaking roof included in this? It is, especially if there is an indication of structural deterioration deficiency as a result of roof leaks. If we have staining in the units below, if we have indications of spalling, corrosion, and things like that, definitely roofing systems and corrosion and leaking roofing systems are included. Masonry walls, steel framing systems, windows, wood framing, the loading on the building, and so on and so forth. For electrical service, branch circuits, conduit raceways, and emergency lighting, and other components of the electrical system. Somebody's asking, is the GFI outlets in wet areas part of it? It is definitely something that is looked at. And again, because this is a life safety condition, anything that can cause a fire or be a detrimental or could cause a loss of life, loss of property would most likely be included in this report. And yes, it does include interior of private units. It does include inspection of individual panels in your unit. So depending on the level of investigation, it may include all the units, sample of the units. Some people have their own panels replaced. Nonetheless, all of that is being evaluated by the engineer. So the engineers or the architect would go into your unit, would check the outlets, would check the panels, the wiring, and so on and so forth, wherever accessible and visible.
So the electrical panels always becomes a legal issue because the delineation of responsibilities for maintenance, repair, and replacement of the condominium components are really allocated by the Declaration of Condominium and the other governing documents. So in just a couple of minutes, I'm going to talk about some of the things that building owners, building operators, CAMs need to do to prepare for the inspection so that they have a little bit of advanced knowledge on what may be required for them for the building to actually achieve compliance.
So on your screen, you do have, I just wanted to show you a couple of examples of how does this report look. So as you can see, this is something that you can download. And they're changing throughout the years, and they are some municipalities are making them more accustomed to their own logos and whatnot. But in reality, as you can see, it's a fill in the blanks type of a report. So there is not too much descriptiveness going on. There's not much explanations. It's basically this is what your system is, and this is what the condition is. And so on. Who are the responsible parties? So who does what in this process? And I think this also presents a lot of challenges to people when it comes to this particular process. Is people are not really sure who does what and who is responsible for what. So in simplest way, the municipality has the responsibility to issue the notices to you, and obviously to, penalize you if you don't do anything about it. So they have that notification function, and also, making sure that you follow through with whatever is required as part of this process. But bottom line is that's where their role stops. Everything else is done by you, the owner, and the professionals doing this report. So who can do this? The only allowed people to do these particular trades or professionals to do the 40-year certifications are either licensed engineers or architects. When I say licensed, they need to be professional engineers in the state of Florida or licensed architects in the state of Florida. There is no such a thing as a local certification, municipality, Miami-Dade 40-year certification specialist, and things like that. Those things do you can have people wanting to have such designations, but their signatures are not accepted. The only signature and seal is accepted is by a professional engineer or a licensed architect. So what do? They perform the inspections and they complete the report for this process. Finally, the owner. The owner has the requirement, obviously, to follow through with everything that is required by the city. And also, once receives the report, the owner is the one that submits the report, and based on the evaluation and the final outcome of the report, has to perform repairs as necessary. What is very important in this process is that municipality does not perform any inspections. So you don't have any building department inspectors or anybody like that coming and checking the building for themselves. Not in this process. So as a result of 40-year, municipality does not come out. They don't send their own inspectors. They don't do anything pertaining to this except sending you the notice. And also, they do not provide opinions on the report. Like engineer writes, you have to do this, and then you go to the building department and say, well, my engineer is a little bit, on a cautious side. We don't really need to do this, right? Well, not right. The building department doesn't have authority to overrule the engineer. So whatever the engineer writes or the architect, whatever they write usually goes. So that puts a lot of responsibility on the owners to make the selection of the engineer or the architect right. To check their references, to check their backgrounds, to check their experiences, basically to do a proper vetting of the professionals that are going to be doing your work, because you can have 3 different professionals giving you 3 different opinions as to your 40-year rectification. And we'll touch on that later on when we go into a little bit more of examples and answering some of these questions that you're posting on your Q&A.
But now we're talking about the responsible parties. This is the first time, this is really the perfect time to talk about the legal issues that community associations will need to look for. Now, number one, the consequences of noncompliance. And of course, you don't want to face the code compliance process, but as a worst case example, if you fail to comply with the building department, with the inspection requirement, you fail to attend to the repairs that are necessary for life safety purposes, the ultimate penalty could be revocation or temporary revocation of your certificate of occupancy. What does that mean? That means people will need to evacuate the building, and it won't be capable of occupancy until you attend to at least those minimum requirements. Now, that doesn't typically happen. What typically happens is it goes before the Unsafe Structures Board or the Code Compliance Board, and you're given a period of time to ensure that you either have the report done or that you have the specifications for the repairs necessitated by the report, identified in the report, and then there are some fines and some penalties that you'll have to deal with. But as a community association, we just talked about, Sinisa just indicated that the individual electrical panels can be inspected, the GFI outlets in individual units, windows were one of the components. So right off the bat, as a preliminary issue is, do you have access to the units? Do you have keys to the units? Have people changed their keys? Do you have owners that will be object to entry into their units for this purpose? So that's number one. If you do not have access to the individual apartments, that's something to work on now, way before your inspection comes up. Secondly, open permits. What if owners have obtained permits to do work in their apartments but never received the final inspections? Or even worse, what if owners have done electrical work within their units and not obtained the required permits for them? Does that electrical work change the load on the building? These are all things for you to do your homework in advance so that when the time comes, it'll be something that you can address or at least have notice of, so that you can work with the appropriate people to make sure that it's resolved. Because none of the, as in my experience, none of the building departments will pass you on the 40-year inspection if there are open permits or expired permits or other problems with respect to unlicensed or unpermitted work within the building. As far as like non-building related legal issues, of course, the allocation of responsibility. So windows, one of the big things. Somebody had a question about railings, who's responsible to pay for the repairs or to effectuate the repairs. Between you as the building association or CAM and the building department doesn't care. They just want the work to get done. The work needs to be done, and it's up to you to compel whoever is responsible to do the work. Well, how do you do that? Well, that's something also to think about in advance, because what if you don't have appropriate remedies? What if you have to attend to the repairs just to pass your 40-year inspection, but then don't have an effective way of reimbursing the association for the common expenses it expelled in attending to an owner responsibility? So you work with your counsel to see what kind of changes or what kind of provisions in your documents will put you in a good position to compel those repairs or compel the work that's necessary, closing the permit, having all the work, having the inspection done for individual unit owners to obtain permits if there were no permits associated with electrical work. What are your rights and remedies, and do you have an effective way to move forward with that? Other issues, somebody brought up the insurance issue. Not having performed the 40-year inspection can dramatically affect your insurance. Some of the carriers will refuse to even renew you or offer options for coverage unless that has been complied with. In other cases, you may have major exclusions from coverage or impaired coverage as a result of failing to attend to that issue. And then also think about your unit sales. People are much more savvy now. So people that are buying units are looking to see if you have reserves. They're looking to see if there are any lawsuits associated with building maintenance or people complaining that things have not been performed. People are looking to see if that 40-year inspection was done. And if it wasn't, that may reduce the marketability of the units. It can impact the financing of purchase and sale in units. And it can also impact, of course, your ability as a community association to obtain financing if you would like to obtain a loan for some other type of project. So those are just some of the things that we talk about from the legal side as to what you can do beforehand, because you don't have to wait for the 40 years. Number one, and this was mentioned earlier, you always need to attend to building maintenance. So you always should be working with professionals to ensure that your building systems, structural, electrical, plumbing, the HVAC are safe and are actually going to perform for the residents. You have an obligation as a community association leader to act in the best interest of the association with the care of a reasonable person and in good faith. That means that you have to attend to building maintenance, building repairs, and not hide your head in the sand like an ostrich because you think that some other future owner or some future board is going to attend to it. That's number one. Number two, of course, you are partially responsible for the safety of the occupants. If there's a failure and somebody tragically, if there's a tragic accident and someone is seriously injured or dies, think about your liability issues and that impact on future insurance renewals. So when we think about responsible parties, as I said earlier, the building department does not care. It's going to be up to you as a building owner, building manager, building association to make sure that this work is done. How it gets done, who pays for it, are not the concern of the building department. That's something that you're going to need to contend with. And you don't necessarily want to do that within the we're going to talk about the timing, but within the 180 days between the time the report is filed and the time that your emergency repairs need to be effectuated. Let's move on.
Okay. So while Lisa was giving you this excellent explanation of some of the issues that you need to understand, I was looking at some of the questions, and I just feel that before we continue, I just need to clarify something which also has been used in the industry as a common term, even though it's probably misleading. And that is, when people mention 40-year inspection, a 40-year process, everybody automatically thinks of a large project, concrete restoration, and all kinds of stuff needed to be done on the property. In reality, that is the case when we don't maintain the properties. But if the property is properly maintained, if you keep your building on a regular painting schedule and you paint every 7 to 10 years and you attend to any concrete defects and deficiencies, if you make sure that your generators are properly running and you replace them in accordance with your reserves, hopefully you have reserves, you replace your switch gear boards, you attend to all of these things, the 40-year process is basically just a inspection and a letter from the engineer, and no action, no further action required. The 40-year becomes an ugly beast once the property is not maintained, because not just that you have to fix it, but now you have time constraints and the building departments that are micromanaging this process from a time perspective for you. Basically, they're going to be imposing deadlines for the property. So in reality, if you maintain your property, and that's why I keep emphasizing on maintenance, if you maintain your property, this is a purely administrative process. This is basically, you are mandated to hire a professional to go inspect your property and write a report saying your property is in great condition. Similar to you going to a doctor for your well visit, and because you are exercising and you are eating healthy and you have no stress, yes, nobody, but never mind. And the doctor says you're okay, and you go home, nothing else. But if you don't do any of those things, and you go to your well visit 10 years after your last well visit, and your blood pressure is through the roof, and you have a tremor in left leg, who knows? So that's the same thing with the 40-year inspection process. If you attend to your building, purely administrative. If you don't, a capital improvement project. So what is included? And we'll hit the time frames. My next slide is going to be on the time frames. So we'll touch base on when do you get this, what do you do, and how much time do you have. But the submittal includes the report and includes the letter. So every report is accompanied by a letter from an engineer that basically gives an indication of repairs are required or no repairs required. If the repairs are required, then you are obligated to repair them. If they are not, no action needed. And obviously the payment. This was written in old times, so everything was hand delivered to the municipalities and building departments. Recently, I believe that everybody accepts now electronic signatures, electronic reports, and all that. So this process might have been changed a little bit, but in reality, this is something that was the responsibility of the owner to deliver this to the building department. Time frames. Notice is issued at 40 years, with a caveat that depending on really how well the building departments are keeping their records, it may be at 41, 42, 45, who knows? I know some buildings that are 50 years old and never received a restitution requirement. So everything depends on the city. How do you know when your building is 40 years or about? You can look at, you can call your building department. So at the municipality where you're in, you can call them and find out. You can look at the property appraiser's website. Basically, everything is done based on your folio numbers. Whenever the folio was established, that is when your date of your building is. Somebody asked a question about conversions. my experience has been that regardless of when the conversion happened, the original date of the building is what building department looks at. So let's assume that you have a building that is 43 years old, but you did a condo conversion in year 37 and completely renovated the building, basically a brand new building. You will still have to comply with a 40-year recertification. The thing is, in your particular example, it will be a very simple one because everything is brand new. So there is really no reason for you to do anything on a building.
There was also a question about multi-building property. So the folio number for the particular building is going to control when the inspection is due for that particular building.
That is 100% correct. So there are multiple properties that have 4 associations and a master, and every tower has its own folio number. The 40-year is going to hit each tower independently and then master independently of all of them. So you may be doing 40-year for building 1 this year, for building 2 next year, for building 3 2 years from today, and so on and so forth. And again, this is governed by the municipality. If they don't send you the letter, you don't have to do anything technically. Again, you should maintain the property, but as it pertains to this process, you shouldn't be doing anything administrative. They don't accept, or at least they didn't accept, early submissions. So, you know we are coming for a 40-year, it's year 39, we'll do our report and everything and just send to the city. No, they don't accept it until they send you a letter. You are not obligated to do anything.
Okay, but that doesn't mean you don't want to have your building evaluated. Somebody asked a question about, well, this could be expensive. How long do we have to get the work done? The earlier that you have an evaluation of your building systems is the earlier that you have to plan for repairs, the longer period of time that you have to fund the repairs, the longer period of time that you have to seek financing to fund those repairs. So again, building maintenance should be an ongoing process. I mean, that goes without saying that, but that being said, some buildings are in better shape than others, and there can be for a myriad of reasons why. If you know that you're approaching this 40-year period, do what you can as early as you can so that your owners, number one, will be prepared, and that you as a board or as a CAM will be able to impart to the owners why this is so important.
And you can see some of the time frames. After you receive the letter from the city that you are due for this 40-year or 50 or 60, you have 90 days to issue to conduct your inspections, or to hire somebody to do your inspections and to submit the report. Basically, if your building is okay, you're done. If your building is not okay, then you have 180 days after the report has been submitted to the city to complete the repairs. Now, this is important because a lot of things are missed in this particular 180 days. And this is the note number 1. Performing these repairs usually requires a permit. Because it requires a permit, you have to hire a contractor. Because you have to pull a permit, you have to have an engineer create a set of sign and seal plans. Your report submitted to the city is nothing but a report. It does not serve as a plan. It does not serve as a sign and seal documents for repairs. It's purely as a report stating that the repairs are needed or not needed. But once you have to perform the repairs, now you have to pull the plans. Which means you need an engineer to create a set of plans for you, sign and seal. Then you have to have a contractor hired. Lisa will refresh your memories for condos, for HOAs. What does it mean hiring a contractor, especially on a project that are going to cost more than your whatever percentage of the budget?
Right. Well, bidding is required for condos and cooperatives. Bidding is required if the project is going to cost more than 5% of your annual budget. But think about this timing, 180 days, 6 months. Seems like it's a very long time, but it's not, because the report is already done, that you know. It takes the engineer a period of time to write up the specifications. Then you go to the bidding process. Some associations like to use closed bidding. After the bids are submitted and before the bids are even submitted, the contractors like to come out on site to review the project with the engineer or review the bid package with the engineer. Then once the bids are submitted, the engineer typically will perform a comparison for you so that the board can make its decisions. And then also think about the funding. So what if you need a special assessment? What if you need financing? Hiring a contractor, you're going to have to make payments, initial progress payments to the contractor, initialization payments to the contractor. Do you have the funds available to do that? So your bidding process is very important. The specifications is very important. And in my opinion, having the engineer perform contract administration is also crucially important, because what is the point of having fabulous specifications that require all kinds of details and the use of certain products unless you also have someone that is verifying that the contractor has utilized those products, has performed the work according to the specifications, and will approve or will review the payment applications to ensure that all the work that's included has actually been performed to satisfaction.
So as you can see from this, 180 days is hardly sufficient to maybe even start the project, let alone complete it, because of the competitive bidding, because of the permit requirements, because of the contract negotiations, mobilization. Sometimes that process alone, especially on a big project like a concrete restoration, it can take 4 to 6 months just to get to the point where we actually have a contractor on site. Now, the building department is allowing extensions in 180 days increments if you show progress. So if you don't do anything, you're going to be in a lot of trouble. If you show progress and you say, okay, we are in the process, we hired the engineer, we hired the contractor, here are the plans, we are submitting for a permit, all of that, then the building department is going to say, great, here's another 180 days. Let's see what you're going to do in this next 6 months. But if you don't do anything, you're going to receive a citation, you're going to receive a fine. And then if you continue not doing anything, you are most likely going to receive a red tag, which basically means that the building department has the option of closing parts of your building, or sometimes in extreme circumstances, even the entire section or the entire building, evicting the tenants because of unsafe conditions. Very rarely comes to this, but I've seen Miami Beach doing such extreme measures for a very non-responsive condo association. So that then means you have to hire an attorney, you have to go in front of the magistrate, and you have to defend your case and show that you are showing effort. What Lisa said is very important. Once you start this process, the city is really have no sympathy for your financial problems.
Right.
They don't really are gonna be listening whether you have problems, loans, previous tenant defaults or anything like that. They only care about the problems, the life safety issues that are preventing normal occupancy of the property.
Absolutely, absolutely. And that's regardless of whether you claim the work under your documents is required to be performed by the individual unit owner. The city is not involved in that internal process. The city is there to ensure that the work that's specified is performed.
So somebody posted a question, once the repairs are required, then the city will be involved. Of course, once the repairs are required, city will be involved. What I was referring by city's involvement was purely from the 40-year process. So from the inspection side, city is not involved at all, nor city provides an opinion as to whether this report is okay or not. City is only going to use that report to enforce it on you.
So here's a good question, Sinisa, that I'd like you to speak to. Someone asked a question, is that what if the association engineer performed a code compliance inspection and not a safety inspection? What do the building owners or CAMs need to do when they're speaking to engineers before they have them, or they hire them to complete this process?
And that's a great question, and it goes to what I said, the 3 different engineers or professionals, 3 different reports. At the expense of sounding the way I'm going to sound in being an engineer, a lot of people in this industry, both between engineers and contractors, have seen 40-year justification process as a very lucrative business. Because as city has given, or the municipality has given very loose requirements to the engineers as to what they can file under the 40-year justification process or not, and basically relying 100% on their opinion in the report. You can have an engineer that says you have to rebuild your entire building. And the city will say, well, your engineer said so. So, you know, go and start building. What can you do in those situations? You can hire another engineer and have a different opinion. However, if you have filed with the city, I'm envisioning that that's going to create a lot of commotion, and you'll have to have a lot of justifications and you know, meetings with the city explaining why first report said everything is wrong and why second report said nothing was wrong and no work was performed in between, because no permits were pulled and nothing was done. So I envision that to be something that's going to require a lot of legal involvement at some point. So going back to what Lisa said, you have to be very careful with this. You have to understand the process first, what this process is. And second, when you interview your engineer, your professionals, you have to make sure that to understand what are they going to be looking for, what are they going to be inspecting, and what is potentially going to be part of your 40-year. I'll give you an example, railings. There are a lot of buildings that have railings that are not currently code compliant. They have, let's say, aluminum railings with pickets that have spacing between the pickets of 6 inches versus 4 inches that is a current code requirement. That is not something that you have to repair. That is something that you have to replace. You're so-called grandfathered in by that because it was okay with the time the building was built. But you may have an engineer that says that is not code compliant, that is not okay, and now you have to redo everything. So in that sense, the interview process is critical, but also why these webinars and your you know, personal education on this subject, so you can ask the right questions of your professionals once you're ready to go through this process.
Exactly. So you need to vet the engineer or the architect that you hire for this process exactly the same way that you would vet any other contractor that's going to be performing services for your association. Number one. Number two, verify that the engineer that you hire for the process has the appropriate expertise, because there's both the structural side and the electrical side, and there are some engineering firms that are structural, and there are some engineering firms that are electrical, and there are some engineering firms that have all various types of practices, including fire safety, including civil, environmental, and what have you. So when you are interviewing the engineers or the professionals that you think are about hiring for the project, make sure that they can do all the work that's necessary to submit a complete report.
And I want to touch base on the question of open permits, multiple properties, and the cost. Unfortunately, the cost of this particular issue is something that I wouldn't be able to provide you here. The cost is tailored to each individual property. Obviously, the cost for a 40-story building with 370 units is not the same as for an 8-story building and 22 units. So the cost of the process is something that would be given based on each individual property. And I'll talk to you about something that I like to refer to as a pre-40-year inspection process, which is going to give you some clarity on how, in my opinion, you should approach this particular issue. Now, in terms of the notices, the notice has to be delivered to the management or to the board of the building. The notice is never delivered to each individual unit owner if you're living in a condo or an HOA. The notices are delivered based on a folio number of a common element to the entity in charge of that particular entity. We spoke about what comes next after submittal, so I don't want to linger on this side. We spoke about if you need repairs, you have to have, you most likely have to have a permit, you have to have an engineer or a contractor. We spoke about that. Now, this is what I wanted to touch base on. This is very, in my opinion, important. Somebody asked, what if the engineer used the wrong template? Well, nothing, they just have to correct it and write it on a proper template. It shouldn't be a problem. A lot of time happens that the municipality has a different templates. You would just have to have your engineer resubmit the paperwork using all proper templates for that municipality. But again, individual professional opinion is what is given in this particular report, meaning different professionals, different reports. I cannot emphasize enough understanding how important it is for you to vet your professionals before hiring them. And sometimes, I mean, not sometimes, we are all, have our own personal things, and we always like to pay less if we can. So sometimes in this process, paying the cheapest may not be the best solution because, again, people use this as a business or very lucrative business. So you pay cheap to get a report, and then the report says you have to, rebuild your building. So you may want to consider who you're hiring.
So Sinisa, how do you decide what units you're going to look at? I mean, I know obviously you look at the roof and you look at the outside structure and the building, electrical systems, but how do you decide like how many units need to be inspected and where in the building the units need to be inspected and things along those lines?
So again, because this is absolutely given to the individual professionals, it is a determination of the professional and a financial reason as to how many units would be inspected. Most of the time, professionals inspect sample of the unit, and based on that, write a report indicating that all units should be addressed in the repair. Sometimes we go in every single unit, but most of the time it is a sample of the units because sometimes going in all the units becomes cost prohibitive. Of the time spent, and especially circumstances like this, where we have Corona and all of this happening around us, people are very reluctant to allow engineers and professionals or a third party visiting and inspecting. So it is up to the engineer to decide the level of certainty they can achieve that this report is going to be sufficient to represent the entire property. Bear in mind that the city looks at the engineer the same way. City is going to look at that report bearing the signature and seal from the engineer with the same scrutiny as it would any other document, which means the engineer becomes professionally liable for the content of that report. And that's the whole purpose why this was thrown to the engineer. So
now you also mentioned something else, because we talked about this the other day. What is that 25% rule? What does that mean? And if you find that a certain amount of the portion of the building is deficient, does that mean that you have to bring that entire component up to snuff, or how does that work?
So the city has, the Florida Building Code has certain requirements when it comes to repairs versus replacement and certain alterations on the property. In certain instances, you are required to bring everything up to code as a matter of repair. So, for example, if you have roof problems, if 25% or more of the roof needs to be repaired or replaced in any 12-month period, then you have to replace the entire roof. So in those instances, even though you may not need to do the whole roof because of these code requirements, you are going to be obligated to do so. And that is a very important aspect of this. Even though this is not a code compliance project, if repairs are required, those repairs are going to have to be done following the current code. So you may not need to replace all the railings on the property, but if you are fixing railings on 3 units and you're removing the railings or something like that, most likely the railings that are going to go back are going to have to be code compliant, which is going to make your building look, with different types of railings because you don't want to replace all of them. So repairs that a result of this are going to have to be code compliant. But if you don't have to touch it, it stays the same way it is. And when we talk about the cost, I think it's very important for everybody to understand one thing. When you are hiring an engineer, and again, going back to interviewing the engineer, when you are hiring an engineer, make sure to understand what is included in the report, because the report in itself, if you need repairs, is not enough for you to pass the 4th year. Now, I'll give you an example. You hire an engineer, an architect, and he or she does an inspection of your property and finds a bunch of problems. Submit it to the city. And city says, okay, owner, go do the repairs. You now go to that engineer that you hired and say, okay, give me the specs. The engineer is going to say, okay, that's going to cost you X dollars. And you're going to go, wait, I hired you for a 40-year report. And the engineer is going to say, yes, I gave you the 40-year report. Well, but I didn't pass. Well, I never said you're going to pass. You hired me for a report. I gave you the report. Now, because you have to do repairs, now you have to hire me or somebody else to help you fix the property, which we go now to the whole process of bidding, vetting, construction administration, permits, special inspector forms, and whatnot. Could be a 3-year project, could be a 2-year project, which means you now have to have an engineer that is going to be doing inspections, reporting, and all of that to fix the building. And now, finally, at the end of all of this, guess what? You have to issue another report that now says you have passed. So I'll give you a scenario. You hire engineer A to do your report. Engineer A says you have problems. You say, fine, how much to fix it? Engineer says, my service is going to be X amount of dollars. Oh, you're too expensive. I'll hire engineer B. Okay, engineer B goes, does the repairs with contractor, everything is fixed. And now you go back to engineer A and say, okay, now give me the report that everything is fine. Engineers say, I don't know that everything is fine. I wasn't here. Now I need to do another inspection of your property, bill you again, and issue a report to confirm everything is okay. And God forbid, because again, this is individual opinion, that engineer A disagrees with the repair that engineer B did. You may be in a problem there. So I'm sorry that I cannot see your faces, but I know when I do this live, there is this look on everybody's face in the audience of looking at us as a bunch of thieves and crooks trying to trick the association. I'm just telling you how the process is. The process is, unfortunately, that if you have to do the repairs, then you have to go to this process, which brings me to my pre-certification report. Somebody asked how much in advance should we start this process? I always say, don't ask your engineers to give you a 40-year certification. Tell your engineers, hey, give me a report, what I need to do to pass my 40-year inspection. And then your engineer can do a study that is going to be more detailed. It's going to give you information of the quantities, of the type of damages that you have, that you can use then potentially at a lesser expense to create specs with that same engineer and do the whole construction and finish this. And the best time to do that, and you know your buildings, if your building has problems, and you don't need to be an engineer to walk around the building and see the concrete, the rebar, the cracks, and things like that. If you know your building has problems, give it a year and a half, 2 years before your 40 year. If your building has no problems, 6 months is enough. That's my rule of thumb when it comes to how soon should you start your process with this.
That's good advice.
And somebody asked about open permits. I'll let you know this. If there is an open permit on the property and you're doing the 40 year, you will most likely have to close the permit before you can pass the rectification, because open permit implies there is something being worked on, which means it's not compliant, it's not safe because it's a construction site. So most likely, if you have open permits on the property, you won't be able to close or complete the 40-year certification process until you close all the permits. Sometimes they're gonna just lump everything together. All open permits plus the 40-year, they're just gonna throw it in one big pile and say, until all of this is done, no 40-year.
And that's been my experience, particularly with the Fort Lauderdale Building Department. And that's regardless of whether the open or expired permits apply to common element repairs or common element projects or individual owner projects. So it's another thing to take a look at, because sometimes correcting or closing those permits requires inspections and certifications and all kinds of work that, that may become somewhat tumultuous, especially if there's a dispute between the association and the individual owner as to who's responsible to do that. So that's something that you can always do early. That's something you can do periodically, just so that you are aware of any conditions impacting your building. Because as I mentioned, some of the people that are purchasers out there, some of the realtors out there, becoming very, very savvy, and they're going to start looking for these things in connection with the sale purchase process or in connection with any other financing type of issues. Plus, I'm not aware of whether the insurance companies actually do those searches, but from my personal experience from my home, I do know that the insurance companies are requiring far more certifications than they did in the past, especially if your buildings are of a certain age.
And Lisa, I just want to answer a couple of questions. I think this is some good questions here. Somebody said if the engineer report is 10 years old, is it still valid? Most likely, the city is not going to accept the report that is dated 10 years ago. So you will most likely have to have that report, reissued with a current date, which begs the question whether that particular engineer that wrote the report is going to be willing to give you the same report 10 years later, not knowing what has happened on the property and what is the validity of such report. So something that has been 10 years old is most likely not going to be accepted and will have to be, updated.
Hopefully people aren't confused. I'm sorry to interrupt you. Hopefully people aren't confusing a reserve study with this inspection report. Now, a reserve study is a very, very useful tool, And in my opinion, more associations should actually engage engineers or reserve analysts to perform these studies so they know what projects are coming down the pike or where they have exposure. But the reserve study is not the same analysis that's done as an inspection report for this recertification process.
And another clarity, I just want to, on this open permits thing, I don't want to create a confusion there. When I say open permits, I imply master permits, something that is for the building. So let's say that you started a stucco project on your property or roof replacement on your property. And then 40th year comes in and you have to do the 40th year. You won't be able to close the 40th year until you do that roof or that stucco project. But in a sense, if somebody is doing a interior renovation of the unit and things like that, I have never heard that being preventing closing of the 40th year. So
actually, I've had that experience, and that is if in the experience that I had for the properties that I represented, it's where work was done without permits in the individual units that caused a holdup or a hiccup in the 40-year inspection process.
The thing about how do you know whether something was submitted or not, again, you would refer to your folio numbers and then calling your building department. Bear in mind, this is one of those things, damn if you do, damn if you don't, because if you didn't do it and you call the city and find out whether you did it and they find out that you didn't, oh, they're going to have an aha moment and they're going to, okay, now that you didn't do it, now, here is the letter, do it now. And if you did do it, no worries. I'm, not sure what is the best approach aside from telling you what I told you from the beginning, and that is maintain your property. If you maintain your property, whether you did 40 year or 50 year or 60 year, it becomes irrelevant because you fulfill the intent of that report, and that is keeping your property safe, which means even if the city wakes up one morning and says, oh, wait, we forgot about this building, and they give you a letter, you are purely going to go through a misty process rather than anything else. If you do reports in advance, you can keep them, again, you can keep them in your possession until you get a letter. The only question becomes whether the city is going to accept any reports that are outdated, or if the engineers are going to be okay to update the reports without performing additional inspections or costing you more money. So in that sense, this is one of those business decisions that you will have to make. Yes, once the repairs are done, the engineer has to come back and do the inspection. The good thing is if the same engineer that did your inspections and your repair is going to be the one providing the justification, then basically they don't have to come back. They were already there. They've seen everything fixed. So at the end of the project, they just have to they just have to issue a report. So there is really no inspections, no additional work necessary. You just had somebody spend X amount of time on your building checking that everything is done properly. So at the end, they just have to fulfill this, fill the blanks in this report, and that's it. I don't know if I can go and try to answer some more of these questions. I don't really know our time frame on this. Some of these we have answered.
Okay, so yeah, we're just at the end of our time, and we did answer the bulk of the questions, but as Jeff indicated earlier, both of us will take a look at some of the questions that weren't answered in the report that we received afterwards. And you, as a participant, number one, are entitled to a copy of the presentation. It is going to be downloadable in connection with the evaluation that you should receive. And we are able to send out the report with the questions and the answers as well. Now, anyone that requires CE credits, continuing education credits, we really need you to fill out that evaluation, because just like you guys are subject to scrutiny from the government, so are we as education providers. And we want to make sure that we have that information on file should we ever be questioned after reporting the credits for the presentation. There were some questions about distributing the information to other unit owners. I feel like that is fantastic, because as a community leader or as a CAM, the more that you can educate your unit owners as to what may be coming down the pike or your responsibilities, so they don't think that you're making something up or that you want to engage in work that, you know, may not otherwise be necessary. That is fantastic. That's one of the reasons why I advocate for the reserve studies and updates to the reserve studies every now and then as well, because notification to the unit, remember, the unit owners are the owners of this property, and they're responsible for payment for all the costs associated with this property. And even as a community leader, you're a unit owner, so you want to make sure that they have the benefit of the information that you have. There's a question about replay. I think we're both going to be posting a copy of the video onto our respective websites, so it will be available for replay should you so desire to forward to your other board members that were not able to participate today, or make it available for display for your unit owners.
Lisa, I want to just interject. You're correct.
Okay.
It'll be available on the firm's website. And also, while I have a lot of ears here, sorry for the interruption, I just want to mention that when you leave the meeting, your browser will then have the link pop up for the evaluation. On that evaluation, you also have a button to download the slides of today's presentation. So you have that opportunity as well. And in addition, tomorrow morning, if for some reason your browser doesn't get pop-ups, or you miss it, or you X out by accident, tomorrow morning's follow-up email will also contain that same link for the evaluation, with the button also to download the course materials. This is especially important for CAMs and for those of you calling in who will not see this. So for those of you calling in, please be on the lookout tomorrow if you need the credit for the evaluation tomorrow morning. Back to you. Sorry for the interruption.
Great. Thank you, Jeff. Great information. So our contact information is available on the presentation and, of course, on the emails that you received. Sinisa, any final or closing comments you'd like to make?
Well, first of all, I would like to thank you, Lisa, and Kay Bender and Rembaum for organizing this and allowing me to present for the people on this webinar. As Lisa said, we are available. We'll try to answer all your questions so you can get complete information out of this webinar. I'll tell you one thing that I heard somewhere, I stole, because I think it's very, very important. In this process, you have to trust your professionals. You have to have a certain dose of faith in them, but at the same time, you have to have a healthy dose of paranoia as well, keeping them on their toes. So that's what I could, if you can take something from this, is be smart about who you choose, how you choose, and try to be well educated about this process. And thank you very much for bearing with me this morning.
Well, thank you. Your expertise is very much appreciated by all of us and by all of our participants. Thank you, everyone.